The Eric Sanford Chapman appellant. For the appellant, Mr. Goldrosen.
That's ready.
And for the respondent, Mr. Friedlander.
Ready. We'll proceed initially in the matter of Lyle versus Warner Brothers Television Productions, hearing first from Mr. Levin. Justice Chin is absent from today's proceedings, but the counsel have stipulated that he may participate by way of listening to the oral argument session. All right, Mr. Levin.
Thank you. May it please the Court. The issue before the Court today is whether sexual speech used by writers on a television show that includes sexual themes, storylines, and dialogue violated the Fair Employment and Housing Act, or FEHA. As I will explain, because the speech was job-related, it did not alter the conditions of employment for the Lyle or any other employee on the Friends production, and thus did not violate the FEHA. Despite the job-relatedness of the sexual speech, the Court of Appeal below held that in order to avoid liability, the writers must establish to a jury that every joke, comment, and expressive gesture was creatively necessary.
What is the test for something being job-related or not? Or, on the other hand, just being incidental, perhaps, to a particular job or profession?
Your Honor, more than a decade ago, the U.S. Supreme Court wrote that freedoms of expression require breathing space. And in the context of a job where writers, as one of the tools of the trade, must use sexual speech, must at times use even vulgar speech, job-relatedness means that they must be allowed to explore all matters of sexuality. This is not Aguilar, where there were directed racial epithets. This is not this Court's decisions in Miller, where we had sexual favoritism. It's not the U.S. Supreme Court decision in Harris or Meritor, where there are sexual propositions. But freedom of expression and breathing space requires that the writers be permitted space to go down blind alleys.
Does it have to be essential, or is it just enough if it's helpful to the process, in this instance, a creative process?
Your Honor, if the sexual speech is job-related, then it doesn't alter the conditions of employment. An essential test or a necessity test ultimately will chill speech. Writers can't be expected to be sitting in the writer's room evaluating their every word and questioning themselves as to whether I can prove to a jury that this will be necessary, or whether I can prove to a jury under some other nexus-type standard.
Does it matter that some of the alleged offensive and harassing conversations took place outside of the writer's room?
Your Honor, we don't think so. As the evidence in the record indicates, the creative process, the speech of the writers was not limited to the four corners of the writer's room. The writers, as part of their job, would discuss storylines and themes and discuss dialogues in the writer's room, but also as they proceeded to the break rooms and in the surrounds in the work environment. And Your Honor asked where the line's drawn. This is not a case of directed epithets. This is not a case of sexual propositions. This is not a case of persons breaking laws of general application, like taking unlawful drugs. It's not a case of persons even having sex in the writer's room. But it's our position that when writers, as part of their job, must use sexual speech, again, to quote from the U.S. Supreme Court, one man's vulgarity is another's lyric. Well, it's particularly apt here because one of the tools of the writers was to use this speech.
You're not contending, then, that your argument would permit criminal conduct or would excuse conduct in violation of the penal code?
That's absolutely correct, Your Honor. We don't contend that the writers could violate the penal code. But what we do say is that the FEHA should be construed narrowly in such a way as to accommodate the First Amendment rights of employees, and not just writers. This may apply to the chambers of your honors, who in speaking with your law clerks may discuss facts of this case. It could apply in my law offices. It will apply in museums. It will apply in any kind of a workplace where, as part of one's job, one must use speech that may be offensive potentially to others. And in order to avoid a First Amendment issue, the court should narrowly construe the alteration of the conditions of employment prong of the FEHA so that speech related to one's job does not violate the FEHA. And that's where the Court of Appeal below was in error.
So are you conceding that if these writers were working on a children's project, Finding Nemo or something of that sort, that this same conduct would not be excused?
I think it's very likely, Your Honor, that a trial judge, exercising sound judgment could find as a matter of law that this kind of speech would or may not be appropriate in the writer's room for Finding Nemo or in the writer's room on Sesame Street. But in our writer's room, where the show dealt with sexual themes and storylines and dialogue, the writers needed to, as part of their jobs, take on taboo subject matter. They needed to challenge social mores. If I can draw the Court's attention to Clerk's Transcript 687 and Mr. Stevens' declaration, he indicates that the show many times dealt with subject matter which was challenging to those social mores and challenging to taboo subjects. But since the beginning of time, that's been the nature of comedy.
Counsel, is your position that the immunity you're arguing applies to the writer's room is absolute? Are there any limits to what could be actionable in terms of, say, race or religion or gender?
Your Honor, first of all, we aren't arguing for any kind of immunity. In fact, we're saying that the Court need not even reach the First Amendment issue here, because if the Court construes the FEHA in the way that we believe it should be construed to accommodate the First Amendment issues, then we don't need to get into the First Amendment issue. But what we're saying here is that there are limits, no question about it. And it's not just limits on writers, it's limits in any workplace. Like in Aguilar, writers on Friends could not direct epithets at an employee because of that employee's race. Like in Miller, employees could not give sexual favoritism, which was rampant in the Miller case.
Well, Aguilar dealt with First Amendment issues. Miller, of course, with the creation of a hostile work environment. Which of the two is pertinent to your particular argument here? In response to your to a question from Justice Moreno, I thought that at one point you said, if this court were to agree with your views, there is no need for this court to reach First Amendment issues. Did I hear you correctly?
That's correct, Your Honor.
All right. Taking you away from the First Amendment at this point and focusing on the hostile work environment that plaintiff complained of. Earlier in your argument, I think in the first few seconds when you started your argument to the court, you said something about, or you mentioned the term job-related. I gather that in this particular case, the plaintiff was on the job 4 months before she was fired, right?
That's correct.
Is it also correct to state that when plaintiff interviewed for the job, and I think two of the writer-producers interviewed her, they specifically told her that the show, of necessity because of the themes it dealt with, had a lot of sexual talk, very frank talk, and at times vulgar remarks pertaining to sex, etc., etc. And is it correct to say that plaintiff at that point said this wouldn't bother her at all?
That's correct, Your Honor. That's at Clerk's Transcript 499.
Did the writers also tell plaintiff, in this job, we require you to type very fast? Plaintiff at that point said, no problem. I can type 80 words a minute. I also gather from the record that I've gone through that the writers asked plaintiff whether she had the ability to take accurate notes pertaining to the development of jokes, writing material for the show, etc., etc., and plaintiff indicated she had no problem. 3 weeks before she was fired, she was given a warning by the writers that, number one, she was unable to keep up with the fast note-taking, And number two, I think the record also shows that her transcription of the discussions was not quite accurate. And there was no improvement, and she was fired. Is it also correct, based upon my recollection of the record, that when plaintiff was fired for not typing fast enough and not taking accurate notes of the jokes that were being developed, a man was also fired for the same reasons?
That's correct, Your Honor.
So what is your response then, having, on my part, talked about the facts quite a bit to put all this in a better context to understand? What is your main argument pertaining to the creation of a hostile work environment? Can you quote, or cite rather, to this court, pertinent U.S. Supreme Court authority that, from your perspective, you think helps your case?
Well, I think I can do better than that, Your Honor. I can cite this court's authority, which in the Miller case, this court held that to constitute a hostile work environment, speech or conduct must be so severe or pervasive that it alters the conditions of employment. The court observed that this is a context-specific inquiry, and the facts that Your Honor just outlined are the context in which this case must be viewed in. And as Your Honor correctly pointed out, this is a context where the plaintiff knew ahead of time that she would be exposed to sexual speech. In the 5 previous seasons of the show, the male and female writers had used sexual speech as part of creating this show. She briefly worked on the show for 4 months. She never once complained about sexual speech, although she complained about other things, which were resolved by the Court of Appeal on summary judgment. In that context.
And in response to my question as to whether you knew of any U.S. Supreme Court authority, you said, I can do better. I can cite the Miller case to this court. Now, let's assume that this court, in analyzing this case, takes a close look at Title VII cases of the Federal Act pertaining to civil rights, enacted in 1964, and doing that also takes a look at U.S. Supreme Court authority. Are you in a position to cite a particular case that may be helpful to your view? And later I'll hear, of course, from the opposite side.
Your Honor, we believe that the Oncal case or Oncali case is quite helpful to our view. And it was a case that this court relied upon in the Miller case. Oncal is helpful both in terms of explaining what is meant by an alteration of the conditions of employment, but also in terms of what is discrimination or harassment because of sex. And I'd also like to draw the court's attention to the Breeden case, which is the one U.S. Supreme Court case that deals directly with the question of an alteration of conditions of employment. And in that case, the plaintiff, as part of her job, had read an application in which there was sexual speech. And her supervisor read that statement out loud, smiled, cast a glance to a male coworker, and the plaintiff believed that that was harassing. The U.S. Supreme Court found that in the context of her job, that there was no alteration of the conditions of employment. And we believe that the same is true in this case.
There's 2 parts to the test, as I understand it. One is that you referred to alter the conditions of employment and be severe enough or sufficiently pervasive to do that, and create a work environment that qualifies as hostile or abusive to employees because of sex. Which of those 2 prongs are you saying the nature of the work takes out of the picture?
Well, Your Honor, I actually believe that both. One, that because it's work-related, there has not been an alteration of the conditions of employment because the conditions of employment included exposure to sexual speech. But also the because of sex requirement. There is no evidence in the record here that the writers spoke of sexual subject matter because of the gender of the plaintiff.
Well, most of it was, however, derogatory or directed toward females.
Your Honor, I believe the record shows that the sexual speech about which the plaintiff complains related to sex acts, which involved men and women, and much of it was actually utilized in the Friends show in one form or another. And that's the nature of comedy writing, is taking on these sexual subject matters and trying to make them funny. And that's what the writers sought to do.
One further question. You've already been asked, are there any limits to what is permissible given the nature of the work here? And you said that penal, criminal acts would certainly be a limit. But short of that, she was advised when she took the position that it would involve sexual themes and have lowbrow humor. Having read the facts and the allegations and so forth, I'm not sure that lowbrow humor would have prepared her for what she ultimately, being in the room, was exposed to. And I suppose the writers could have gone even farther short of criminal acts. Is there no limit up to the barrier of criminal acts?
Well, I certainly think that if there were directed speech of the form that this court addressed in the Aguilar decision, that would absolutely be a limit.
I mean, directed in this case at her.
Directed at her. And this isn't, frankly, Your Honor, this isn't even a case like Fisher or Beta, where the plaintiff had been subject to directed speech and also sought to rely upon harassment of third parties. There's no evidence in the record that the speech that related to other parties was actually harassing of those other parties. So I think that within the facts of this case, the writers needed to have the freedom and the breathing room to explore sexual subject matters, and even those that, again, take on taboo subjects, because that's what the show dealt with.
Counsel, is there any distinction in your mind as to because of sex prong in the comments that are directed generally to women and other comments that were directed to, I think, one or two particular actresses?
Your Honor, I don't think so, because the comments were about actresses, or the alleged comments. I'd like to state that we've taken the record as it is because of the procedural posture of the case, but the respondents actually dispute a great number of those allegations. But nevertheless, accepting the record as it is, there's no evidence in the record that even the alleged comments about the actresses were motivated by gender animus. There's allegations, for example, about comments involving fertility. The show has dealt with themes involving the female character's fertility. It's reasonable and logical that in coming up with those themes, the writers would discuss the character's fertility and what it might look like to be, or how unhealthy it may be to be too skinny, and how you might not be able to bear children, and how they might want to work in that social issue into the show. So yes, it's conceivable that to develop themes and storylines, the writers may at times mention a character by the actress's name.
As to the writers, is it correct to say that here the writers were, well, there were male writers, but there were also women writers who also, in the course of developing plot lines for the show, frankly discussed sexual themes, etc., etc.?
Yes, Your Honor, that's absolutely correct. There's actually in the record the declaration of Plummer, the declaration of Meehan and the deposition testimony of Plummer and the deposition testimony of Kaufman, all of which have given examples of women discussing sexual themes. And Plummer and Meehan specifically said that they understood that the sexual discussion was part of the job of being a writer, and that they themselves were not offended by the sexual discussions. It was one of the tools of the trade of being a writer on a show that dealt with sexual themes, much like the writers on shows like Sex and the City would have to talk about sex. And on cable shows that deal with nudity, employees may even have to be exposed to nudity. On Friends, there was no need to be exposed to nudity. And to respond to Your Honor's question about drawing lines, I think that a judge might properly reach the conclusion that if the writers had taken off all their clothes in the writer's room, that would not be job-related. But we don't have those facts in this case.
So what is the crux of your argument? Would it be correct to summarize it as follows? That there was no evidence, based upon your argument, that plaintiff would have been treated differently had she been a man?
That's correct, Your Honor. That's one of our arguments, and then the second argument being that the severe pervasive prong, or the alteration of conditions of employment prong, should be read narrowly to accommodate the First Amendment rights of the writers and the other respondents, and to allow job-related speech to continue without punishment under the FEHA.
In the 4 months of plaintiff's employment, did she ever complain to the writers that she was offended by the frank sexual discussions?
She did not, Your Honor, and in that way she was somewhat of a stealth plaintiff because she knew coming into the job that she would be exposed to sexual speech. And during her brief 4 months of employment, she was exposed to sexual speech. There's no dispute about that. And though she complained about other subject matters, matters which have now been resolved on summary judgment and affirmed by the Court of Appeal, she never, until 1 year after the termination of her employment, she never complained about sexual harassment.
What if the case involved the termination, Warner Brothers terminating the writers because of this conduct? Would the test be the same?
Well, Your Honor, if the writers had at-will employment, I believe that the company would have the right to terminate them at will. And I hope I'm answering Your Honor's question, if they had employment contracts that only allowed them to be terminated for good cause, then certainly the use of sexual speech would not constitute good cause.
The problem becomes more magnified were this case to be adjudicated on a freedom of speech theory. Isn't that correct?
Yes, Your Honor. If the court finds that the speech here did alter the conditions of employment, then the court would need to tackle the bigger issue, or the broader issue, of what are the boundaries of the First Amendment in workplaces such as this. But if the court reads the FEHA in a narrower fashion to accommodate the First Amendment concerns, such that work-related speech would not be punished under the FEHA, then the court need not reach the First Amendment issue in this case. If I may, the Court of Appeal also erred by placing the burden of proof on the respondents. The Court of Appeal suggested that it would be the respondent's burden to demonstrate creative necessity. It has always been the case that the plaintiff shoulders the burden of establishing each of the prima facie elements of a harassment claim, including that speech or conduct was so severe or pervasive that it altered the conditions of employment. So by placing the burden on respondents, the Court of Appeal made a legal error. The necessity standard also is problematic, in addition to the reasons that I've articulated, because it would allow the punishment under the FEHA of speech that is protected by the First Amendment. The Court of Appeal also erred by making this a jury issue. As this court held in the Shulman versus Group W case, when First Amendment concerns are present, the most appropriate remedy is summary judgment. And the same is true in this case. Though we believe that the court can resolve this case by narrowly construing the alter the conditions of employment requirement, the case nevertheless does implicate the First Amendment. And it's the First Amendment that's driving the narrow construction. And if plaintiffs are allowed to bring these cases into the trial courts will be cluttered with cases like museum security guards offended by displays at museums, teachers' assistants suing professors for sociology lectures that mentioned sexual history, employees in religious institutions who are offended by religious speech in the religious institutions. And not only will trial courts be cluttered with these kinds of cases, but the courts of appeal that have a responsibility to review de novo First Amendment cases will also be cluttered. So you have the chilling effect that the Shulman case noted because of the protracted litigation, and then you have the congestion of the court. Those two considerations suggest that this is an issue that should be resolved properly by a trial court on summary judgment rather than by a jury.
So you're saying, in effect, that to the extent we apply familiar maxims of jurisprudence and avoid constitutional issues by construing these causes of action more narrowly, we protect the First Amendment rights because we don't have to get to those issues and, what more, clutter courts in resolving those.
That's correct. As to Your Honor's first point, by construing the FEHA in a manner that we believe gives proper deference to the legislative intent, which is to prohibit disparate treatment, discriminatory conduct, but at the same time construing it in a manner that facilitates First Amendment rights, the court can avoid the constitutional issue. And by making this an issue that can be properly determined by a trial judge on summary judgment, the court will avoid the congestion of the trial courts and the courts of appeal.
Now, you've mentioned job-related. Does that encompass the totality of circumstances that you would look at in determining whether or not there's been a violation here?
Mr. Chairman, you may respond to Justice Baxter's question, but your time is otherwise up.
I'm thinking also of the length of employment, for instance, where it's a relatively short period of time, matters of that sort.
Yes, Your Honor. In the Miller case, this court did indicate that the totality of circumstances is one consideration, and the length of employment here was very short. The plaintiff did not complain. She had been told that she would be dealing with sexual subject matter. The show in previous seasons had dealt with sexual subject matter. Male and female writers used sexual speech, although the plaintiff elected just to sue the male writers. The totality of circumstances in this case demonstrates as a matter of law that summary judgment was appropriate because there was no alteration of the conditions of employment. Accordingly, we ask that this court reverse the Court of Appeal.
Thank you, Mr.
Thank
Levin.
you.
Mr. Cummings?
Thank you, Your Honors. May it please the Court. Monty Lyle's contention is that the facts that the respondent is presenting, that these facts had something to do with the creative process of Friends, is a complete fiction. That if her contention is that if you were there and understood how these facts were being presented and how they were being said, where they were being said, and you would understand that nobody was involved in a creative process at all, this was just some guys liking to say shocking, offensive, vulgar, obscene things.
When you say guy, just some guys, are you using it informally, or does the term include women also? I need to clarify because you may or must have heard, or may have heard the response from opposing counsel in response to my question as to whether the writers had male and female writers. And so when you said these guys, I needed clarification.
I was referring to the three named defendants, Mr. Chase, Mallins, and Reich, when I was referring to, those were the individuals Monty Lyle in her allegations identified as the primary people or writers or producers, however you want to characterize them, that were charging and fueling this type of discussion all over the workplace. And it wasn't discussion about writing a show. It was just how they liked to speak for their own personal gratification, their own personal kicks, if you might want to put it that way.
Mr. Cummins, I would like to take you to the law at this point because that's where, of course, the fight is going to be, applying the law to this particular case. And then I would like to hear from you what result you want us to adopt and why. Now, you may have heard arguments earlier where, in response to questions from the court, opposing counsel acknowledged that based on relevant case law, there are two requirements that you, representing the plaintiff, would have to show. Number one is whether the conduct was discrimination because of sex. You may have heard the answer from opposing counsel that here the comments of a sexual nature were not directed at plaintiff, as counsel argued, nor were they directed at women in general. So I would like to hear your response to that.
Yes, Your Honor. First of all, the law from Fisher to Miller, your most recent decision, clearly states in the line of cases from Fisher to Miller, directed speech is not required to have a sexual harassment or a hostile work environment. But in relation to this specific case, there was directed conduct, and a lot of it that...
Directed at whom? You would have to show that it was directed at plaintiff herself. My recollection from the record is that except for one comment, none of these comments complained of were directed at plaintiff herself.
Well, in this case, Your Honor, we have conduct that's verbal, nonverbal, and we have visual and in words. For example, if we want to look at the directed conduct, there is non-sexual directed conduct that we presented. One, Amani Lyle could not go to her supervisors and talk to them about her performance like the male writers could, and she was told this by the male writers that they were allowed to do this, and she wasn't. For example, when she would bring up ideas or be in the writer's room, she would be condescended to, talked to in a disrespectful way as if she was stupid. The male...
Ask you this, though. How would you answer the argument of Mr. Levin that, with reference to the pertinent test, there was no alteration in the conditions of employment or in the work environment because that was the work environment, those were the conditions of employment, and that those were made clear to her before she commenced employment?
The conditions of employment were that is objectively abusive and demeaning to women. That's the condition that was altered. Is the plaintiff had a right to be in a condition where it was free of sexual harassment or discriminatory conduct.
If she's told that there is going to be sexual banter back and forth, and that happens, where's the alteration in the conditions of employment?
Okay, this idea, for example, we have the discussion in the deposition with Ms. Lyle regarding sexual themes and lowbrow humor, which I would think if somebody said to that, I'd say, yeah, that applies to the Friends television show, but I would never think that means some guy next to me is going to be drawing a woman's vagina and making jokes about it. I mean, there is no evidence that she was warned of the vulgar nature of what was going on and the types of things that we were talking about in this case.
Did they have to anticipate everything that would come up in this process, which has been described as a creative process, in advance of her first day on the job for them to give her notice of what the conditions of employment might be?
First of all, for example, drawing pictures of women's vaginas, our contention is, and a reasonable inference from a trial, a jury would be, is that has nothing to do with writing the creative process. It's just somebody who has a hobby of drawing vaginas. And it's an offensive thing, and it should be in the workplace. So there's this type of conduct. There was no, on Friends, you had no competition for drawing vaginas on Friends and making that part of a show. This individual enjoyed doing extremely offensive things. It was his own personal gratification. That's what he did, and it expanded from there. And I would like to say that the conduct that was created that was so demeaning to women expanded into conduct where women like Miss Lyle, when they said something, they weren't taken seriously, they were treated as stupid, they wouldn't be allowed to go to talk to their supervisors about their job performance.
What you are arguing to the court, is that in the record?
Yes, Your Honor.
What is your response to comments made by opposing counsel earlier, where counsel pointed out that here, and something I went into with you earlier, there were both male and female writers, and both male and female writers, quite frankly, talked about their sexual experience, etc., etc. So I would like some clarification when you argue to this court that here the writers engaged in totally improper behavior, and I presume under applicable law you would have to show that these comments were directed at your client.
Well, this last part of your question, under applicable law, in terms of Fisher said it didn't have to, hostile work environment did not have to be directed conduct. The most recent case, Miller Department of Justice said, to create a hostile work environment, you do not have to have directed conduct. But what I was trying to point out was the directed conduct that was based on sex, that was non-sexual, that if you look at a party was part of the total. It can be, you can create a hostile environment from non-sexual conduct that's just discriminatory in nature. When you treat men and women, you can have double standards, which we had here. We had a double standard in
Why
terms.
was there a double standard? I thought that, based upon my recollection from the record, a man was fired for the same reasons. He wasn't taking dictation fast enough, and he couldn't accurately write down the development of the plot lines.
That's correct, Your Honor. But we also pointed out at least that her replacements in deposition was testified that her replacements were both white males who had the same types of deficiencies. They were not fired. We pointed out in the record several individuals, named individuals, that were testified to as having the exact same types of deficiencies as Miss Lyle, who were male, who were not fired. There was a definite double standard as to whether a woman can type all right or a man could type all right. Somehow it was more forgiving for men who didn't type fast in that environment.
Now, how does that take us to the hostile work environment, sexually saturated, altering the conditions of employment? That's really a separate issue, is it not, that we've gotten onto here?
No.
Men who couldn't type so fast were left on the job.
This case is a case that takes into account a similar analysis that was done in a CARDI, which is based on a hostile work environment that includes a lot of non-sexual conduct, but it also takes into account a lot of other cases that involve sexually charged and conduct of a sexual nature that's offensive, that is severe and pervasive enough to rise to the level of abuse.
Well, all right. But for my information, this case that we are looking at now is unique, is it not, in that it arises in the context of this creative environment. Am I correct that far?
Well, there's no doubt that this is a Friends show, and that this is the people that are supervising Miss Lyle are part of the writers that write that show. But a reasonable jury, a reasonable trier of fact, could most easily infer that what happened on this show that Miss Monica Lyle is complaining about had nothing to do at all with writing Friends. So in that sense, if you accept Miss Lyle's contention as true, as you should in summary judgment, then basically these facts, if accepted as true, do not have to do with the writing of Friends.
Well, as I recall, the many allegations in the declarations, they were widespread, and they were allegations of vulgar and offensive behavior and what have you. But from your point of view, the jury, if it were to go there, would have to parse out what kind of behavior or words or drawings generated a creative idea that made it onto the show, and what part were purely gratuitous. Am I correct?
Well, the jury would have to do a totality of the circumstance analysis, which would take into account, and certainly the respondents would argue that this conduct was related to the creative process. And within that totality of the circumstance argument, the jury would consider the facts in context and what they believe to be true. So the totality of circumstance analysis takes into account the idea that this is content or contextually driven. And the jury's going to have to look at the context, what's presented to them as to how these things were being said, how these things were being done, and whether or not this is just a fiction, as we contend it is, or whether there's some merit to it. And based on that analysis, I believe the whole idea of whether or not the creative process is involved would be hashed out. And yes, it is a factual analysis that needs to be looked at by a jury. And what we're arguing is that a reasonable trier of fact could find that all the conduct taken as a totality, looking at everything that occurred from the non-sexual conduct to the visual harassment to the verbal harassment, everything taken as a totality, a trier of fact would reasonably find that this is an abusive work environment for women, that demeans women, and that it rises to a level of discriminatory work environment. And to try to connect the two, it's very, in harassment law, when the law also talks about altering or affecting a woman's ability to perform her job. And we have that in this case, because the allegation is Ms. Lyle was not allowed to talk about her performance to her supervisors. And since she was being denied the ability to talk about her performance to her supervisors, where the other male writers were being allowed to, this is definitely affecting her ability to perform her job, and it's definitely altering a condition of employment. But it's also altering a condition of employment in terms of in hostile work environment, the denial or the effect on her personal well-being. The fact that she's living in a degrading environment where women are just playthings for males who want to demean them and make fun of them and create this demeaning type of environment. And then when a woman like Monty Lyle wants to bring up an idea, she is shot down and disparaged and condescended to it and treated as she's stupid. And all this relates to the hostile work environment, affecting the performance, affecting her emotional state, and affecting her abilities to be free from discrimination in that workplace. And that's the ultimate goal of FEHA, is to protect people like Monty Lyle from being, she has a right to be free from discrimination and abuse in her workplace because she's a woman. And certainly that's the level we were talking about, is an abusive type of situation to women, a demeaning situation to women where they are in a hostile work environment.
Counsel, would your argument be the same if she were a man? And my understanding, the record reflects that there were derogatory comments made about men and their sexual proclivities. Would you say a man in this context would have the same sort of claim?
Well, the things I can recall in the record, for example, are about, for example, there was statements being made that one of the actors on the show was gay, and things of this nature. So we're not saying that the hostility could only, obviously this type of statement was directed at homosexuals versus heterosexual males. So we're not saying that everything was said was necessarily, you could say, was about women, but the nature of that comment, for example, is still demeaning a different type of male other than the white male who is a man and it does manly things. This type of statement even goes to demeaning other types of people in the workplace that aren't like they think men should be.
So your position is that a man would have the same claim, even if the comments were directed about women as well as men?
Well, what my claim is that if you look at the analysis, you have to go to that individual. You have an objective prong and a subjective prong, and you have to go to that individual and saying that individual, based in that circumstance with that totality of the facts, is that an objectively abusive work environment that creates a hostile work environment? Or is it, and then you have to go subjectively. Subjectively, would you find it was also subjectively?
But how are those comments actionable because or based upon sex, from the point of view of the complainant, male or female?
Okay, the comment of, for example, if you had my example was comments that were directed at homosexuals. So you're saying how would a homosexual bring?
No, just anybody.
Well, basically, conduct of a sexual nature I believe in Miller, your most recent case, you point this out, is that demeaning conduct to women could be, an action could theoretically be brought by either a man or a woman.
That's my point.
Yes, so, yeah, that's true. Demeaning conduct towards women could a man that's offended by that could bring an action based upon that, and his...
But how is that action based upon sex? If it applies in this situation to a man or a woman in this environment, it doesn't seem like the claim would be based upon sex.
Well, you got me way in the abstract, so I'm not really understanding what exactly I'm talking about, the situation that's based on sex. But what this, in Fisher, the based on sex is conduct of a sexual nature. It's hashed out as conduct of a sexual nature. So conduct of a sexual nature that is severe and pervasive enough to be objectively abusive and create a hostile work environment for some man would also be actionable if he could meet that standard, and he was subjectively also a meeting standard as well as objective.
But the language is because of their sex, in other words, the plaintiff's sex.
Yes, and...
the conduct is equally objectionable to both men and women. You don't have a FEHA violation.
Well, there's so many ways you can come at because of sex. In other words, you would be...
Because of their sex.
Yes, because of their sex. For example, if you were talking about a party-type case where you're talking about non-sexual conduct that's differential treatment, double standards, mockery directed at one or the other, then, you would have a situation where only women who are on the losing end of the comparison would have a cause of action. But if you have a sexually charged environment that's offensive to both men and women because it's of a sexual nature and it's of an offensive sexual nature, based upon the cases that say what you're really looking at is conduct of a sexual nature.
All right, thank you, Mr. Cummings. I'm afraid your time is up, and we'll hear now from amicus curiae, Mr. Winico.
May it please the Court, Jeff Winico for the California Employment Lawyers Association. I had intended to restrict my argument to the First Amendment, but I want to pick up on some of the themes that the Court is concerned with regarding the FEHA application.
Well, perhaps you can shed some light on the argument that we just heard. And you may have heard questions first from Justice Moreno and then from Justice Baxter, trying to get some clarification as to the applicability of the pertinent law. And you may recall that under applicable law, there are two requirements. Number one, because of sex. Now, are you taking the view that Mr. Cummings is taking, that all that's needed is simply some adverse reaction to sexual comments in general? Or are you taking the view that I think was implicit in some of the questioning from the bench, that the term because of sex means hostility towards the plaintiff's sex? What view are you taking?
My view is that the notion that you can have an equal opportunity offender is not one that is embraced by FEHA. I would direct the Court's attention to the case of Hutchinson versus Amateur Electric Supply at 42 F. 3rd, 1037, which is cited in the amicus brief filed by the Legal Aid Society Employment Law Center. In fact, pages 40 through 42 of the Legal Aid Society's brief addresses the Court's core concerns on this point. That is, what happens when a man is equally offended at comments that offend a reasonable woman? And cases like Hutchinson or Steiner in the Ninth Circuit hold that just because a man may also be offended by this conduct does not cure the defect in that it is a barrier to equality and equal opportunity for the reasonable woman in this workplace. Picking up on an earlier question.
So, if I may, since you have very little time, what is your short answer to the question posed?
My short answer,
Because of sex, what, from your perspective, does it mean?
it means that a victim, because of her sex, experiences different terms and conditions of employment from a man. That the question that this court needs to be concerned with was whether or not the gauntlet of abuse that existed within this workplace was a barrier to equality in the workplace for women or to African Americans.
Does there have to be hostility to the particular plaintiff? That's what I'm trying to find out from you.
Yes and no. I mean, we have an objective standard and a subjective standard. On the subjective standard, the particular plaintiff, to have standing to bring the claim, needs to have experienced some hostility. However, subjective hostility isn't enough. It's got to also satisfy an objective standard that goes beyond the plaintiff, which is where the state's primary concern is in eliminating barriers to equal opportunity in the workplace. It's one thing to say that FEHA is purely a private remedial scheme. Ms. Lyle was injured. How do we go about compensating her? But FEHA is broader than that. We have a public policy that deals with eliminating all forms of barriers to equality in the workplace. And the reason we're here today isn't because Ms. Lyle had a particularly unique or hypersensitivity to the type of workplace environment that she had to experience at Warner Brothers, but because it is argued that this type of environment would be hostile and offensive to all reasonable women and create differential terms and conditions of employment because of their sex.
So is that the standard, that women have a right to have a more genteel workplace because they have entered it?
No, it's not a question of gentility. The question is whether or not this type of workplace hostility rises to the level of severe or pervasive harassment such that it constitutes different terms and conditions of employment. The law has always said the law does not mandate civility. I think that if this statute were construed as a general code on civility, it would fail whatever First Amendment tests were raised by a defendant. But it's not. The focus isn't on gentility. The focus is on equal opportunity in the workplace. And how do we go about destroying these barriers that exist for women and African Americans in a field that is primarily dominated by young white men? And part of the reason why we have a field that is dominated by young white men is because there are barriers to equality in the workplace. It's the plaintiff's contention that this type of gauntlet of abuse is the brick and mortar which keeps those barriers in place, and that neither the First Amendment nor FEHA it justifies maintaining those barriers that exclude women from equal opportunities.
Now, before you conclude, would you articulate for us how this case fits into the test to find that there was sexual harassment under FEHA, the alter the conditions of employment and do so because of sex?
I think because of Ms. Lyle's sex, she experienced terms and conditions of employment, at least with respect to sexually related hostilities and racially related hostilities, that differed from the white male colleagues.
You mean because of her sex, because as a woman, the language and so forth would perhaps generally be more offensive, or because it was directed at her because of her sex?
Well, whether it was directed at her or not, I think, is immaterial, as the court has pointed out in Miller. If the barriers exist, we don't really care how or why those barriers to equality got erected, whether it was because it was directed at Ms. Lyle, whether somebody says that, all women are the C word versus Ms. Lyle, you are. We don't primarily care about how those walls got erected. The fact of the matter is that under FEHA, we look at this case and we see a situation where because of her gender, and it's not just that she was offended verbally, she had to work in an atmosphere where men were viewing women as nothing more than sexual playthings.
Would this then be an argument for the employer next time not fairly to consider a female applicant?
They can, but again, they would be subject to a gender discrimination suit. People always say that in all types of workplaces, whether it's creative or non-creative. One of the downsides to sexual harassment law is that it will give employers a reason not to hire women. They said that about pregnancy discrimination laws. They say that about gender discrimination laws. They said that about race discrimination laws when Title VII was passed in the early 60s.
All right, so what about the first part of the test? You've answered the second part. You've answered the because of sex part.
And then the second part about whether it altered her working conditions. The status quo never justifies employment discrimination. Taking that argument to its conclusion, one would say if we had a sexually charged workplace, whether it's an oil rig in Oncology, or a construction site, or here, a television writer's writing room, that the fact that we're not altering the conditions, we have always been offensive and demeaning to women, again, just keeps those barriers to equality erect. And the point of a law like FEHA is to take down those barriers.
Does it make a difference that this writer's workroom is different from an oil rig? The argument being made is we talk about sex because, this show is about sex. And so you shouldn't be surprised, potential employee, that you're going to be exposed to a lot of sexually charged language.
There are a couple of responses to that. Number one is the fact that it's somehow related to sex. Is a notion that really is stretching it thin. There is no evidentiary record that any of the conduct in this issue, in this action, relates at all to the content of the television show. But even if one were to consent to some sexual discourse, that doesn't mean that you consent to having women treated in a degrading and offensive manner. That strips Ms. Lyle of her dignity. To talk about sex is, one can talk about human relationships and talk about sex in a completely different context from talking about sex in a degrading and it's fair to say, inhumane manner.
Do you think it's immaterial that she was instructed concerning the conditions of employment and that they would involve graphic and vulgar language and that she said that would not be a problem?
I think it's material in that it's a fact that the defendant can bring to a jury. I also think it's material the fact that Warner's told her that if you come to work for us, we'll protect you from sexual harassment. Warner's, I think, also told the writers, if you come to work for us on Friends, you've got to respect our work rules. Leaving aside whatever First Amendment arguments are being made, Warner's is saying one condition of employment is you check your First Amendment rights at the door. You come to work for us, you have to respect a woman's right to work because we're an equal opportunity employer. And so I think both of those facts could be persuasive to a jury. I also think that there's a difference both in degree and kind between the type of abuse that Ms. Lyle sustained and the mere consent to have some aspects of adult sexual relationships discussed in a writer's room.
All right. Thank you, Mr. Winoco. Your time is up. And Mr. Levin, you may argue in rebuttal.
The Court of Appeal below concluded that the because of sex requirement was satisfied based upon its assumption that sexual speech is inherently more discriminatory to women than to men. Essentially, the Court of Appeal was articulating a form of disparate impact type theory, with the assumption being that the sexual words used impacted on women more than men. The evidence in the record, however, demonstrates the contrary. The evidence in the record demonstrates that the female writers participated in the sexual discussions, were not offended by the sexual discussions, and that the plaintiff herself, during the 4 months that she worked on the show, never suggested to anybody that she was offended by the sexual speech. Nothing was directed at her, as has been pointed out. Under these circumstances, the court should find that the because of sex requirement has not been satisfied. This is not Miller. Miller, under its own unique set of facts and circumstances, the court came to the conclusion that the because of sex requirement was satisfied, but under these facts, in this context, that requirement is not satisfied.
Just one question for clarification. We have heard quite a bit as to what the opposing side thinks the term because of sex means. I would like to hear from you what, under applicable case law, the term because of sex, what does that mean? Does that mean a certain hostility to the gender of the particular plaintiff?
Your Honor, it means motivated by gender. And it can be evidenced, as the U.S. Supreme Court indicated in the Oncal decision, by sexual demands. It can be evidenced by comparative evidence of how men and women were treated in mixed-sex workplaces. And it can be evidenced by directed conduct reflective of general hostility to the presence of women in the workplace.
Now, suppose that in a particular work environment, sexual remarks pertaining to women were made, but that a man feels quite insulted by that. Under applicable case law, can that man bring a proper cause of action?
Your Honor, I don't believe so. I believe that unless the plaintiff himself or herself was subject to some conduct that was motivated by his sex or her sex, that he or she cannot succeed under the FEHA. And while there are cases that suggest that evidence of conduct directed at others may be considered, which are the Fisher cases and the Beta cases and a number of federal cases, there is not a case that I am aware of where the only evidence before the court was evidence of speech not directed at the plaintiff. And that's this case. This case is sui generis. It involves speech entirely not directed at the plaintiff, and also, perhaps more importantly, it involves speech that is job-related.
Well, now your opposing counsel on that very point said that this speech had nothing to do with the show.
Well, Your Honor, I think the facts show that it did have something to do with the show, and to the extent that counsel is suggesting that if it's not used in a final aired version of the show, that it has nothing to do with the show, that would be erroneous. Your Honor, creative space or freedom of expression requires that the writers be permitted to go down blind alleys and explore subject matter that may lead nowhere. It requires that they be allowed to take on taboo subjects, that they have false starts even, that they come up with ideas that are put on the back burner and maybe they'll never be used. There's a term in the motion picture industry for the cutting room floor. Many ideas end up on the cutting room floor, but the writers can't be punished for the ideas that aren't used. And so long as there's a relatedness to the speech, and in this case, sexual speech used by the writers was related to the sexual themes and storylines and dialogues on the show. And for that reason, the Court of Appeal was in error, and this Court should reverse the Court of Appeal.
All right.
Thank you.
Thank you, Mr. Levin.